the criminal trial division and come down and sign that.
Yes.
Yeah, that's fine.
No, Megan.
Yeah. Yeah. All right. So the cases you're pleading to is the 2023-7883. That is the evading.
Yes.
And then the other one is the ag assault.
Yes, Judge, I was just informing Rick that the state is waiving and banning the aggravated aspect and making it an assault public service.
Oh, I'll be able to look at the plea paperwork. So I'll walk him through it.
That's right.
All right, thank you. I appreciate it. All right, the court is calling 2023 CR 7884 and 2023 CR 7883 State versus Camila Scon. Could I have parties announced for the record for the state
Rick Pena for the state of Texas.
defense?
Raymond Martinez, Commissioner Calhoun.
And are you Mr. Galvine?
Sure.
Counsel, in each of the cause numbers, have you received all discovery and that you review that with your client?
I have your honor.
And each cause number, the court will find that the state is in compliance with discovery. And each cause number, Mr. Galvine, that you review what's entitled application for deferred adjudication with your attorney. Did you understand it and did you sign it?
Yes, your honor.
And each cause number, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, your honor.
Counsel, each cause number, do you waive the reading of the indictment?
You do, your honor.
State, it appears in cause number 2023 CR 7883. You're proceeding on the indictment as presented with the waiver of a deadly weapon allegation. Is that correct?
Yes, Your Honor.
Is that correct?
It is, Judge.
And then in cause number 2023 CR 7884, you're proceeding on the lesser included offense of assault against a public, assault against a peace officer. Is that correct?
Yes, Your Honor.
All right, any objections to the state's proceeding?
We do not.
All right. Mr. Galvin, in each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, your honor.
All right. And each, in the cause number ending in 8-3, you're charged with evading arrest, detention with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, you could be sentenced up to 10 years in prison and up to a $10,000 fine. And the cause number ending in 7884, the state is proceeding on the lesser included offense of assault against a peace officer. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Do you understand?
Yes, your honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, your honor.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering into this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, your honor.
Counsel, has your client been able to provide you with any defenses?
He has, your honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, your honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, your honor.
Mr. Galvin, has anyone threatened you, coerced you, or placed you in fear to get you to enter into these pleas?
No, your honor.
Anyone promised you anything other than the plea?
No, your honor.
Are you satisfied with the way you've been represented?
Yes, your honor.
Are you a U.S. citizen?
Yes, your honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. And each cause number, did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, your honor.
All right, and the cause number ending in 8-4, as previously stated, the state is proceeding on the lesser included offense And in the cause number ending in 8-3, the state is waiving the deadly weapon allegation. According to your plea bargain agreement in each cause, punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. The state is opposed to your application for community supervision and deferred adjudication. The cases were run concurrently. The state will take in consideration 2023 CR 7882. And there's to be restitution to Sheriff's Deputy M. Molina. Did you understand that to be the plea in each of the cause numbers?
Yes, sir.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Andrew Harris Edelman taking over for Rick Pena. Yes, Judge.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, have there been any such motions?
There have not.
Then in cause number 2023 CR 7883, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
And cause number 2023 CR 7884, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the defendant's plea.
Should be contained in Exhibit 1 and attachments for each case, Judge.
No objection.
All right, state, you may be excused.
Thank you, Judge.
And each cause number, did you review the waiver with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. In each cause number, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Counsel, if you're requesting a PSI, it's going to be 8 weeks. Otherwise, if you would like, I could give you a shorter setting without a PSI, and you can bring in whatever witnesses you would like to bring. And what I can tell you is what I usually request from the state is criminal history. And then I hear whatever witnesses either party wants to call.
Judge, in an abundance of caution, I think we need that inside.
Okay, will there be a TAP evaluation needed?
There was no allegation of drug or alcohol use in our case.
All right, we can go off the record. Is there any need for mental health?
I don't believe so, Judge. No.
All right, Ms. Abrams, on this case, I'll need a PSI. Defense counsel is not requesting a TAP evaluation, so no TAP evaluation will be needed. TAP evaluation is to determine whether or not you have any drug history. So do you think you need a TAP evaluation?
Actually, I gotta go take my drug test after this.
Mhm.
I mean, if it's possible, I could take it right now.
No, it's,
Yeah.
He hasn't had any positive evaluation.
All right, so does he need a TAP
I don't believe
evaluation?
so, Judge.
Any mental health issues in the past that you may need a mental health evaluation?
Right.
All right, I need a PSI date. All right, Ms. Abrams.
Judge, I think that's right, in the middle of next week, and I think I'm taking that week of vacation, 26th through May 3rd. So the 5th is probably okay.
Okay. So May 5th will be that Monday.
I'll be back.
All right. So it'll be May 5th.
Okay. Getting an A3 correct?
Yes.
Okay.
All right.
Thank you, Judge.
Just make sure you speak with probation before you leave and get your reset form.
Thank you, Your Honor.
All right. You're welcome. And State, do you want to tender that TIC?
I would love to judge, but we are out of regular dismissal forms.
Oh, okay. All right, thank you.
So as soon as we get more, we will give it to the court.
All right, thank you.
Where are they? If I knew where they were, I would have more.
I'm sorry, what? Okay, just let me put this down real quick. And then I will-
So she can files shading decision forms from another court. That's so old that they still have 201 here. We put on the values. Here is.
Yes.
Oh, I was talking to.
Hello. Hi, how's it going? Yes, let me come just 1 second. I was just putting this in.
Is it May 5th or May 3rd? You did put 3rd, but I think she said Monday the 5th. So we'll be in the 3rd. But I'll just change my mind.
And just let me know when you're ready. Okay. All right, who's here on Delarosa?
Yeah, let's name a fine art, Your Honor. Delarosa, please come up.
All right, and State and Gary. They're gonna bring him up in one of the cells, and I'm gonna ask for the state and the defense to come to the back with me. All right. All right, court is calling 2024 CR 009256, State of Texas versus Ray Delarosa. Can I have parties announced for the record for the state?
Defendant for the state of Texas.
Defense.
Attorney John Garcia first, defendant, Your Honor.
All right, does he only have one case?
Well, Judge, he has family violence cases too, and then he has one criminal trial division, DWI 30.
All right, so he's only pleading on the family violence, or is he pleading?
And I guess that's what I was coming up to see what was gonna go on with the.
Okay,
The DWI, Your Honor.
all
I
right,
was gonna ask for a couple of weeks on that because I had just done the DPS discovery today.
okay. All right, so in this cause number, you're Mr. Ray Delarosa. Counsel, have you received all discovery? Did you review it with your client?
I believe I have, Your Honor.
Court will find that the state is in compliance with discovery. Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, you are, Sue. We're sitting on count 2 of the indictment and we'll wait count 1.
Any objection?
That's our understanding, Your Honor.
All right, Mr. Delarosa, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand your charge in count 2?
We will also be proceeding, excuse me, Your Honor, lesser included misdemeanor or assault, family violence.
Any objection?
No objections, Your Honor.
All right, did you understand that the state is proceeding on count 2? And they're proceeding on the lesser included offense of assault, bodily injury, marriage cohabitation? That is a class A misdemeanor. The range of punishment is anywhere from $4,000 fine up to 1 year in the Bexar County Jail. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He is, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is, Your Honor.
Mr. Delarosa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, the state is proceeding on count 2, the lesser included offense of assault, bodily injury, marriage cohabitation. They're asking that your punishment be assessed at 26 days in the Bexar County Jail. There's a $500 fine, no applications. There's an affirmative finding of family violence, and they say that this will satisfy the judgment. Did you understand that with a affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea?
Yes, ma'am.
Defense, is that the plea?
That's our understanding of the agreement, Your Honor.
State, is that the plea?
Yes, it is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the lesser included offense in count 2, how do you plead? Guilty, not guilty, or no contest?
No, thank you.
State any evidence?
Yes, Your Honor. Say at this time offers into evidence, say to exhibit 1 with all attachments.
Your Honor, I reviewed that information with my client and we have no objections.
Okay. And state, have you spoken to the complainant?
You've attempted, Your Honor.
All right, and what is going to happen with the other case? The 2024 CR 009261.
Those will be dismissed, Your Honor. I have those for you.
All right, thank you. Sir, did you review the document entitled waivers with your attorney? Thank you. With your attorney, did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
It's on there. On
All right, who is the complainant to you? What is your relationship with Hernandez?
What?
right, so why are you doing this? Why did you end up hitting her? That's what I wanna know.
I mean,
You want a jury trial?
no,
All right, is she still living with you?
no,
Okay. All right, this is what the court is gonna do. Court is gonna find you guilty as previously stated. The court is gonna sentence you to a $500 fine. Time and money to run concurrent. 26 days in the Bear County Jail, give you credit for any time served. There's to be no contact with Herlinda, Herlinda Robles, Robles. And no contact with Crystal, Kirstal, Nicole Alcorta. Did you review and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
yes, ma'am.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of, and I'm sorry, there's also an affirmative finding of family violence. And because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Counsel, how much time do you need with regards to the DWI case?
I was thinking, if I could get like 3 weeks, Your Honor.
All right, Ms. Ferguson, I need a 3-week reset for discovery on his DWI case. All right, we'll be back on March 25th for discovery. So
Thank
once you
you.
sign the reset form, you're excused. Thank you. Good seeing you. How's your
Good to see you.
sister?
Doing good. Everybody's good.
Oh, that's good.
Everybody's healthy.
Oh, that's all we can ask for, right?
Definitely.
All right, just have a seat, sir, and he'll give you the reset form. Are you all ready for me in the back?
Yes.
All right, can I see the prosecutors and the defense attorneys on this case, please?
Back here, Judge?
Yes.
Joanne?
All right.
Okay. You're skinny.
Not all.
I think so. You go. No, yeah. Oh, okay. Oh, you already sworn it? Oh, okay. So we'll just drop- oh, sorry, no, I think we motion to adjourn. We should cover that face mask. I just didn't know what it is. They have to all start. We have their hands. We have one more for you. That was up there. That's it. It's all her. They're not supposed to say it makes her. Yes, forever. No, we have a negotiators come by. There's nothing in your stay. We have extra help. That's it. It's not like it's easy. But why is it like this? No, shock therapy is very convenient, it's very, very helpful.
Mhm.
I don't have a credit card. No? But that's when you have a calculator.
Oh, that's right. You said that.
Oh.
So we got everything done. Except for that.
It's Martinez, okay. You can sit up there so far. Yeah, go. Don't be scared. Don't be scared. And that's your copy of the journal, so you can follow along. Please. Please.
Thank you very much.
That's it. After that, I'm gonna cancel the open and lock it back up.
Can you do that?
Yeah.
Look at no. Oh, this is the right one for
The doctor then, or we put him on an actual chair, because the thing about the chair.
That's good seated, yeah.
They can't move anything.
What you put it here, bro, listen, turn on. You
You just. Gary, and then he was real ugly with me again. Yeah.
It's fine, negative.
It was bad, it was bad. I thought he was gonna take a swing at her since he hasn't seen her see the crush. Yeah, when he was talking, I thought you. I was like, oh my god, I'll probably have to tease him right now.
Would have been some great viewings.
A girl, I was like, oh my god.
You'd be like, and then we would have had a, so alert homes.
We're gonna be good.
And there's gonna be World War III.
There's a drama going on.
Mama would have jumped over and throw punch.
Not what a customer, but. Yeah, no, no one's really good about pressing the button. Yes. That's very, very, she's very good about doing that.
Nice.
And Michelle's very good about moving out of the way. And sits down and observes everything. She embraces. Yeah, good humans, so it gets crazy, right? No, oh my goodness, oh, it's a treat, it's beautiful. It's fun, it's nice. They haven't been yet. We prepared that door stop.
All right, who's here on Rakim Ashmore?
Oh, and Judge, if I could just go grab Miss.
Sure.
And Judge,
Yes,
Okay.
Mr. Gavon.
thank you.
Thank you.
All right, and tap back there and see if they have any objections to me, letting the jurors know it's gonna be a few more minutes.
Don't go by yourself, Judge, don't.
I will not.
Don't go, don't go, I'm just letting you know, don't go.
I will not.
Let him wait, you don't have to go. Okay, just let him wait. They're okay.
They're okay?
Yeah. Don't go.
So why don't we get it?
I love you, Judge, but would you like to roll them out? So no. Unless you're gonna let them go home? or you
No,
could go
that's,
outside.
that's not happening.
Okay, then don't go.
You know, it's like that song, Please Don't Go. From this, I think that's from the seventies.
I'll be part of the sense of United States.
Yes. No, it was yesterday.
Oh, is it yesterday?
Mm-hmm.
I just thought, okay, that's really bad.
Oh, it is.
So at least she's going to report.
Yes.
No, no one's introduced myself. I'm Cassandra. I'm taking your class.
Well, welcome.
Yeah, and I'm the intern here. So.
Okay, that was awesome.
Church.
Well, we should be starting a jury trial shortly.
Okay.
Or she wasn't in the witness room. I don't know what it is.
All right, while we're waiting for that one, Jennifer Hernandez. Where is everybody?
Greco?
Yes.
Her defense counsel is not present in the courtroom, Judge.
That's wonderful.
All righty.
Evacuation judge on 37 and Southton Road.
Why?
Fire. Fresh fire, so there's evacuation being issued in that area. 37 and Southton. Southton.
Oh my gosh, I hope everybody's okay.
What was maybe jurors, Judge? You sure you want to maybe something?
No, it will be fine. Norma, can you call Warren Wolf?
Yes, ma'am.
All right, and Mr. Ashmore, who's your attorney? All right, if you want to call her, because we're gonna start, she's outside? Oh, just knock on her door, tell her to come in.
And Your Honor, I did, I think she was in a Zoom hearing.
Ah,
She told me it would just be a couple minutes.
okay.
Only two.
Yes, ma'am. That was 1 minute ago. To be fair.
All right, court is calling 2024 CR 008783 State versus Rakim Ashmore. Can I have parties approach and announce for the record for the state
Ashley Jones.
defense?
Joanne April for Mr. Aspen.
Did you get a chance to finish your Zoom?
Yes, I did.
Okay.
Just finished.
And are you, Mr. Ashmore?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes,
Court will find that the state is in compliance with discovery. Mr. Ashmore, did you review the document entitled Application for Deferred Adjudication or Community Supervision with your attorney?
Yes,
Did you
ma'am.
understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
We are not, Your Honor. We are going to proceed on count 1 and waive count 2.
Any objection?
No objection.
All right, did you review the document entitled Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That is a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Ashmore, has anyone threatened, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 1. Punishment is to be assessed at a cap of 12 years in the prison. There's a $1,500 fine. State is opposed to your applications. There's an affirmative finding of family violence and there's been no contact with. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the entirety of your plea? Did you understand that to be your plea bargain agreement?
Yes, ma'am.
All right, defense, is that the plea?
It is, Judge.
State, is that the plea?
Yes, Your Honor. The only thing is, we also did check affirmative finding a deadly weapon. I just wanted to
Oh,
make
I'm
sure
so
that was
sorry.
correct.
Thank you.
Yes,
And there's also an affirmative finding of deadly weapon. Did you understand that?
Yes, ma'am.
All right. Did you review the document entitled Waiver of Appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that are filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Judge.
Then to count 1, how do you plead guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
State offers states 1 in all attachments.
Objection, Judge.
And state, have you spoken to the complainant?
Yes, Your Honor.
All right, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find him guilty. Court will defer finding him guilty as you've applied for deferred adjudication. We can go off the record. Counsel, if you want, we can set it for a PSI. It'll be about 8 weeks. Or if you would like, we can recall it sooner. And I will hear whatever witnesses you would like to bring. And I would ask the state for his criminal history.
Judge, I think I need a PSI.
All right, Ms. Ferguson, I need a PSI and a TAP evaluation. All right, May 5th.
Judge, we have one issue.
Mhm.
I'm assuming because of this thing, my client comes off GPS today.
No.
All right, I filed a motion for the court to consider allowing my client to work while he's on the GPS.
All right, any objections to allowing him to work?
Yes, Your Honor, only because of the facts of the cases the court has just read in the stipulations. Additionally, we did speak with the complainant and she does have safety concerns. Those would be the two objections from the state.
All right, this is what I'll do. We'll come back with regards to the hearing on the GPS, and what I'm going to need is proof that he's employed and what his work schedule is.
I have that today, Judge. Well, at least I have the hours that he works and where he's working
From the company?
from the company. Well, me better,
Okay.
but I do have it.
And
How soon, Judge? Because I've been trying to get this since last.
Oh, just speak to Ms. Ferguson,
Okay, we'll put it down. Thank you.
and then you're welcome. All right, Jennifer Hernandez. Court is calling 2025 CR 00744, State of Texas versus Jennifer Hernandez. Can I have parties announced for the record for the state?
Jason Deere.
Defense?
Warren Gold.
And are you Ms. Hernandez? Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Ms. Hernandez, did you review the document entitled Application for Community Supervision with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiting count 1 and the enhanced paragraph, proceeding on count 2 alone.
That's
Any
my
objection?
understanding. No.
All right, so here's the court's question. On some documentation, her name is Trejo Hernandez. On others, it is Hernandez Trejo. So are you Hernandez Trejo or Trejo Hernandez? All right. Did you review the document entitled Court Admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand in count 2, you're charged with harassment of a public servant? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, the court does not have to follow your pleas. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you're in a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes.
Ms. Trejo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
Yeah.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on count 2. Punishments be assessed at 4 years in the prison, and the state recommends community supervision. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver or appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, are there any such motions?
No.
Outside the agreement, the state is requesting that your community supervision be for a term of 4 years, that you be referred for a MIC evaluation and Alpha House. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to count 2, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence?
Yes, sir. They exhibit number one with all these attachments.
No objection.
All right, Jason, I think Bashan wants to speak to you.
Um,
Okay, oh, Bashan. Ms. Draco, did you review the waiver and consent with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witness statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
Judge, if you recall, Ms. Trejo was, Hernandez Trejo was at Alpha House, and there was a motion to revoke her probation. And that was cleared. The recommendation at the time was if we had cleared this case that was outstanding unindicted, they were willing to take her back. So, and I want to thank the prosecution for recalling Ms. Trejo's situation and recommending that she be placed on a mental health caseload because there are issues with her mental health. I had received the standard form from the jail indicating upon her evaluation at the jail, they report her as post-traumatic stress disorder, bipolar disorder, major depressive disorder, and anxiety disorder. So that being said, Alpha House is, I'm sure you're
Yes.
aware of Alpha House, and she was doing well at Alpha House. She relapsed, and that got her into this situation that we're in front of the court today. But I want to thank the prosecution for recognizing the presence of Alpha House. Ms. Trejo wants to return there. She did well there. She appreciates their approach to things, and she believes she can be successful there. And ask that you permit her to do that. I realize all you can do is recommend, because it's they would have to clear.
All right, this is what the court is going to do. Court is finding you guilty. The court will sentence you to 4 years in the prison, suspended and probated for 4 years. There's to be regular reporting by Zoom or in person, regular random UAs, a MIC evaluation, transfer from the Bexar County Jail to Alpha Home. There's should be 100 hours of community service restitution. I'm going to require anger management. Once she completes that, that will be deemed satisfied. There's to be no contact with Joseph Andrew Sanchez, Angelica Nicole Torres. I'm sorry, Joseph Andrew Sanchez, Angelica Nicole Torres, Jorge Alejandro Alonso, Rogelio Valero Jr., Martin Alonso Jr., a referral to felony drug court in custody, proof of employment or SSI within 45 days of release, no employment as a home health care provider or with minors, no unsupervised contact with minors, field visits 1 time per month until further notice, and 90 sober meetings in 90 days. And if there's a need for a renewed TAP or an updated TAP evaluation, then an updated TAP. Probation, is there anything else? Is there anything else you need to be successful?
No, thank you.
You're welcome. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal? Your attorney, did you understand it and sign it?
Yes, sir.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Good luck to you. You don't have to do better. You understand?
Yes, ma'am.
All right,
Thank you.
thank you. All right, let me knock on the back and see if they're ready back there. 'Cause we're gonna start.
It just echoes a lot. He's not very happy, though. Yeah. That's good. It's all good.
All right. They're coming out.
Yeah, I'm the file.
Oh, you need the file?
Yeah.
Sure, no problem. If anybody can read my writing. All right, and Deputy Lord, we're gonna bring him out.
Hernandez Treasury, so the government drug court in custody, in custody.
Yes. And she's currently on probation. So they may not need an updated tab. So we're gonna bring the jury out and we'll start jury selection. And I always say it's good for students to see the process because seeing it as opposed to reading about it is so much different. Yes, please. Thank you. So I can put it in the system.
That finger's like Cindy.
I'm sorry.
Oh, you got it.
Election might be. A good marriage.
Yeah, the election.
I know the election.
You are? Oh.
Pardon? Gary, G-R-O.
All right, each side you'll have 30 minutes for voir dire. And Mr. Porter and Mr. Churek, I believe you both have been in this courtroom for jury selection before, so the same rules still apply.
And we're going on the ag robbery, right?
Yes.
Yeah.
Mr. Churek, can you put your microphone on, please? Yeah, it's on. I can hear you. Either on your lapel or there, either place works. Thank you.
And everyone, just remain seated when the jury comes in.
Yes.
In defense, I do believe if he remains like that, you really can't see anything. Am I right in that?
Are you comfortable? You might want to sit back in your chair.
Well,
Or
they're gonna sit from there, can you sign up?
All right, and do you need a chair on the side of him? Would that help you out?
Like.
There's another chair here, Robert, on this side.
Okay. Benefit's gonna be saying our lives for the jury.
No, that's not. And Deputy Laura,
Body language.
yeah, and just remember, there will be no all rise for the jury.
Okay, just FYI, earlier when the lady from the jury room came, number 32 is getting a really bad anxiety, and number 32 took off.
All right, is there any objection to excusing number 32? State
No, Judge.
defense? All right, number 32 is excused.
And even, she even separated him from the rest of the group, but was
All right,
ready.
yes, we're ready. Let's bring them in.
First row, different from the chairs. Second row on top. Yeah, all of them are full.
Thank you, Deputy. All right, everyone, good afternoon. Okay, that is so weak, and I know you've been saved because it's extremely windy outside, enough wind to blow everybody over, and I thought my weight would save me, but it did not. So, good afternoon, everyone. All right, I appreciate you all for, one, getting here at 8 a.m. to make it to the central jury room, then waiting in the hallway. Sometimes what jurors don't realize is even though you're being called up for a jury, we actually have other cases that are on our docket. So in this court, I usually have about 60 to 70 cases a day. So I try to work through those in the morning, and then we have jury selection at this time. And of course, if all cases are worked through, then you will be here earlier. So I don't want you to hold it against the state or defense or anyone for the fact that you are outside in the hallway. It's just, that's just the way the legal system is. So you are in the 187 District Court on the 4th floor, and you're with Judge Boyd. So what floor are you on? All right, that was said like some of you don't know where you are. So what floor are we on? What's the court number? And who's the judge? All right, now you probably say, why is she asking that? We already know where we are. We've been standing outside for over an hour or more. The reason why I asked you that is because whenever we take a break, you're not allowed to remain in the courtroom. So if ever you all need a break, then that means everybody goes on break. And believe it or not, we've had instances where we've gone on break and we start missing jurors, and the deputies have to try to find them. And sometimes they're in another court trying to be on a jury, or either they say, I looked up and everybody was gone. I didn't know where I was supposed to be. So now you all know where you're supposed to be. I'm going to have the parties introduce themselves to you for the state.
Good afternoon, my name is Megan Galloway and I represent the state of Texas.
Andrew Harris, Salem.
And for the defense?
Eric Jurek with the defendant, Mr. Jose Lopez.
Good afternoon, I'm Robert Porter.
And Mr. Lopez, could you state your name for everyone?
Jose Lopez.
All right. So does anybody recognize any of those parties who just introduced themselves to you? All right. If at any point in time, you know, once you hear attorneys speak, you think that you may know someone, just let us know. All right. So this case is the state of Texas versus Jose Lopez. To my left is the court reporter. I always try to make the court reporter's job easier, but I will tell you this. Every jury that we've had, and we have jury trials usually once a week, has failed to follow this instruction. And I'm going to tell you what I told each of them, but I have faith in this jury that you're going to be able to follow this instruction to make her job easier. So in your possession, you have cards. Could everyone please raise your card? And I want you to keep your card raised until I ask you to lower it. So jurors 1 through 21, lower your card. If you still have your card remaining up, to make sure that the court reporter can hear you, I'm going to need you to stand when you're answering questions. The people with their cards remaining, are you able to do that? Yeah. All right, I have faith in you. I don't know if it's going to happen, but I still have faith in you. All right, you can lower your cards. Now, whenever someone asks you a question, or if there's something you want to respond to, just raise your card and wait till you're called and acknowledged. That will make it easier for the court reporter. So we just need one person at a time to talk. I understand that sometimes we're talking conversationally. And when we do that, what ends up happening is, oh, is there something on? Am I hearing some extra feedback? All right, so when we do that, what ends up happening is the court reporter is trying to take down two people talking at once, and that makes her job more difficult than it needs to be. So in the back room, I'm gonna need you all to speak up, don't whisper, because the court reporter needs to hear your answer. All right, so you're here in the 187th District Court. We try criminal cases here. So Mr. Lopez has been accused of aggravated robbery, and there are two counts. Count one is aggravated robbery and count two is aggravated robbery. When the state and defense speak to you, it is going to be in hypotheticals. Neither the state or the defense is allowed to tell you what they think this case is about. So when they're talking to you, don't go into your mind saying, oh, so that's what this case is about. They're not allowed to tell you what they think the facts are. The only way you will get a chance to know what they think the facts are if you are on the jury. Does everyone understand?
Okay.
So now they're just trying to find out if you would be a good juror for this case. In felony court, the way cases come to trial is by way of indictment. So that means that a case goes to a grand jury, and then somebody is told, we're going to hold you over for trial. Now, that indictment is not evidence or anything. It's just information for the person who's accused, so they'll know what they've been accused of and where they need to go if they decide to have a jury trial. Does everyone understand?
Yes.
All right, we're going to practice raising cards. Raise your card if you have ever had a traffic ticket. All right, well, I will tell you this. This group is one of the worst driving groups of all the jurors that I've ever had. I think, lower your card. All right, now let me do this. Raise your card if you've never had a traffic ticket. All right, you're surrounded by bad drivers, so be careful. All right, you can lower your card. So I've had a traffic ticket too. I've had one traffic ticket in my lifetime. So that's good for a 21-year-old. So, so anyway, when I received my traffic ticket, it was back in the day where the police officer would write on a piece of paper and it was carbon copy. So they had their copy and they would give you a copy. Well, if you get pulled over, let's say you're pulled over and they say you failed to yield, which people tend to not know what yield signs are. But let's say you were pulled over for not yielding. When that officer pulls you over and gives you that ticket and you accept it, you're not saying, oh, you're right, I didn't yield. What that ticket is just to give you notice. Then you go to municipal court. If you want to go to trial, you can have a trial. But that ticket is not evidence of guilt. It's not evidence of anything. And when you think about it, in criminal cases and having a traffic ticket also, it's good for you to have that because you'll know what you're being charged with. Imagine if you got a ticket and it was for a failure to yield, and then when you get to municipal court and you're ready to go to trial and they say, oh, by the way, it's for running a stop sign. Does everybody understand? So an indictment cannot be taken as evidence of anything. Does everyone understand?
Yes.
It's not evidence of guilt. It can't be considered by you whatsoever. Does everyone understand?
Yes.
Is there anyone here who cannot follow that? All right. Now, the next thing I want to talk to you is about certain constitutional rights everyone has when you're charged with a criminal offense. One of those rights is the right to remain silent. I've been a prosecutor. I've been a defense attorney. So when I would have my clients, sometimes as a defense attorney, I would tell them, you don't need to testify. The state didn't prove their case. Or either I tell my client, you're sitting here talking to me. I believe that you didn't do this, but you're sweating. You're nervous. It wouldn't be good to get on the witness stand. I know you, but the jury, the first time they're going to know you is when you take the witness stand. So it's probably best for you not to testify. Here's the thing. At the end of the day, whether someone who's accused decides to testify or not testify, if they decide after discussing with their attorney or just themselves, they decide, you know what, I don't want to testify. Guess what? You're not allowed to consider that. If you are deliberating, you can't say in the back, well, he didn't even testify. That's a point against him. You're not allowed to do that. You're not to consider it at all. It shouldn't be in your mind at all. You can't be like Mrs. Kravitz from Bewitched saying, oh, well, I wonder what he would have said. You're not to consider it whatsoever. And I know I ran across some people, even my own family members, that would say, well, if I were in that position, I would testify. And you know what I always tell people? It's easy to say that because you're not in that position. And maybe you're not talking to your attorney is not giving you certain advice. So with that being said, is there anyone who is going to hold it against Mr. Lopez or consider it in any way, shape, or form if he decides not to testify? All right. Now, the next thing I want to talk to you about is presumption of innocence and what that truly means. Mr. Lopez is presumed to be innocent. Anybody who's charged with a criminal case is presumed to be innocent. So what that means is the state has the burden to prove that someone is guilty, and they have to prove it beyond a reasonable doubt. If you are ever on a jury trial and it's a criminal case and you're deliberating in and back and you're saying, well, the defense should have brought this, or the defendant should have said this, you have just shifted the burden to the defense and you're not allowed to do that. The state has to prove their case beyond a reasonable doubt. So the state has to present evidence to show beyond a reasonable doubt that a crime has been committed and that the defendant or the accused is the person who committed it. Does everyone understand?
Yeah.
So if you had to vote right now on whether Mr. Lopez is guilty or not guilty, what should your vote be? All right. And the reason being is because you have not heard anything and you don't know anything about this case. And the only way you're going to know something about this case is if you are on the jury. Does everyone understand?
Yes.
When I was in law school, the way every professor would explain it to his students was this. Defense can sit over there, they can play board games, they can play Candyland, Chutes and Ladders, they can go to sleep, they can read the newspaper. And the reason why all our professors would say that was to stress to us the fact that the defense does not have to prove anything, doesn't have to prove innocence. Does everyone understand?
Yes.
Now, of course, do I think these two attorneys are going to play crossword puzzles or Chutes and Ladders or go to sleep or read newspapers? No. But I'm stressing to you that the burden is the state's burden and the defense doesn't have any burden. Does everyone understand?
Yes.
Now, I want to talk to you about the presumption. I want to talk to you about the burden of proof. The burden of proof in criminal cases is proof beyond a reasonable doubt. So the state has to prove each and every element beyond a reasonable doubt. What's the definition of proof beyond a reasonable doubt? We don't have one. When I was in law school, we had to memorize the definition. And if you didn't memorize it, your professor let you know that you were such a failure. So I knew it backwards and forward. My first jury trial that I had, I was so proud of myself because I said the definition. I had the comma where the comma should go. I paused for dramatic effect. See that pause I just gave you? That was the dramatic effect. I would put exclamation points where there needed to be. After my first jury trial, they did away with the definition. So neither the state nor the defense can tell you what proof beyond a reasonable doubt is. But the way I would explain it to jurors was by telling them what it's not. Next door, you have the historic courthouse. That's the courthouse with the green rooftop. They try civil cases over there. So their burdens are preponderance of the evidence. More likely than not, something happened. So if ever you're deliberating on a criminal case, be it misdemeanor or felony, and you're in the back deliberating and you're saying, well, I think this happened more likely than not, you are not at the right burden. You have lowered the burden of proof that the state has. The other burden next door is what's called clear and convincing evidence. Clear and convincing evidence is the type of evidence they use to terminate your rights as a parent to your child. So they say you're a danger to your child, we're going to take your child away from you, can't be trusted with your child. That's a very high burden. But there's one burden that's even higher than that, and that's the highest burden we have, and that's proof beyond a reasonable doubt. Does everyone understand? Right. Now, proof beyond a reasonable doubt, let me just tell you, one, it doesn't mean beyond a shadow of a doubt, which I'm sure some of you all may have heard from Perry Whit Mason, the paper chase, Mannix, Barnaby Jones. But that's not the state's burden. The state's burden is proof beyond a reasonable doubt. Does everyone understand?
Yes.
So sometimes the state will ask you, do you think we've proven our case? Do you have a doubt? And is your doubt reasonable? Does everyone understand? Now, the next thing I want to talk to you about fairness. What does fairness mean? Because people will say, are you going to be biased in this case? Are you going to be fair? And then people will usually give you an example. And this is the example I've seen people give to jurors. Let's say you're being called down for jury duty. You are so excited that you're coming to jury duty because you want to do your civic duty. I see y'all running here at 8 a.m. I tell you to slow down, it's hurry up and wait. But you plan your route and then you get up and you come downstairs and you go outside and you find your vehicle is on cinder blocks. Somebody's stolen your tires, they broke into it, they smashed it. But you planned ahead, so you call the police, they come out and do their investigation work, and you said, I'm still gonna do my civic duty. So you take an Uber or the Via, you come downtown, you make it just in time for 8 a.m. and you get called up to sit on the jury, and the jury is a burglary of a vehicle case. Let that marinate for a little bit. Usually the state will say, this isn't the proper case for you, or the defense will say, this isn't the proper case for you, is it? The true question is whether or not, if in that same instance, you find out you're going to be sitting where someone is charged with burglary of a vehicle, whether or not you're going to look at that person and say, my vehicle was burglarized. This person is charged with burglary of a vehicle. I'm going to find them guilty. I'm not listening to anything because I'm upset. I'm ticked. So what fairness means is whether or not, if you're placed on a jury, that you will be able to listen to the evidence that's presented to you. And if you can come to a decision, you'll base your decision upon the evidence that's presented. Does everyone understand? Because at the end of the day, nobody was born yesterday and slept all last night. We all have different things that are happening in our lives. So is there anyone here? This is an aggravated robbery case is what he's been accused of. Is there anyone here, based upon what I just told you, cannot be fair? All right, the next thing I want to talk to you about is there are two phases to every criminal trial. The first phase, people call it the innocence phase, but that's not really the correct term. The first phase is, did the state prove their case beyond a reasonable doubt? Or did they not prove their case? That's the first phase. If in the first phase, somebody is found not guilty, there's no second phase, because the second phase is what's called the punishment phase. In Texas, everyone must make an election on if they were found guilty, who would they select to choose their punishment. In this case, Mr. Lopez is saying that if he were found guilty, he would like for the jury to give punishment. Is there anyone here who's going to hold it against Mr. Lopez because he's elected the jury to give punishment if he were found guilty? All right, next I'm going to talk to you about punishment. In this case, the range of punishment is anywhere from 5 to 99 years or life in prison. And in some cases, if it's determined at punishment that someone may have been convicted previously of a felony more than once, then their range of punishment could be 25 to life in prison and up to a $10,000 fine. Now, Those are wide ranges of punishment. When I say 5 to 99 years, that means you go from the number 5 and count all the way up to 99 years. And then beyond the 99 years is life. If punishment begins at 25 years, then you start at 25 years, goes all the way up to 99 years, and then life. Does everyone understand? Now, if you ever have a case where someone has a previous conviction, your only concern is making a determination of whether somebody is guilty or not guilty. You don't even think about punishment. Does everyone understand? So hypothetically, let's say someone has a burglary, an evading arrest detention with a vehicle case, right? And previously they've been convicted of evading arrest with a detention of a vehicle. When they come to court, you're not supposed to be considering that they previously been convicted of an evading arrest with the detention of a vehicle. You just want to know this time, did they do it? Does everyone understand?
Yes.
So when you think about punishment, think about it this way. How many of you have children? All right. So here's the thing, and I'm bringing up my mom's parenting techniques that she used with us. She was a talker like I'm a talker. So if she were to tell you your curfew is at 8 p.m., she'll sit down and tell you, all right, you can go with your friends, but your curfew is at 8 p.m. And then let's say you come home, but you violate your curfew. You come home at 9 p.m. What my mom would do in that situation is she'd sit down and have a conversation with you and she'd say, hey, didn't I tell you your curfew was at 8 p.m. and not 9 p.m.? You'd be like, oh, okay, right? And then maybe when she's considering my punishment, if I were to violate it again, she would say, hey, I told you your curfew was 8 p.m. on this day. You didn't come in at 8, you came at 9. And then I told you again, it was 8 p.m. and you come in at 9 again. And so maybe she would say, hey, you're not allowed out anymore. Now, as a side note, I never broke curfew, but that's what I mean by things you consider in punishment. But mind you, that's not something that my mom would consider if I didn't break curfew. So she wouldn't immediately say, oh, your punishment is going to be you're not allowed to go out before she even determines if I broke curfew or not. So in any case where someone may or may not have prior convictions, you're supposed to concentrate on whether or not they're guilty of what they've been accused of. Does everyone understand? Because there are sometimes you may have somebody who's accused of something when they're a teenager. Maybe they went through rough patches and then they've got their self together and then they get accused of something else, maybe 10, 15, 20 years later. And it's like, hey, I didn't do this. So is there anyone here who cannot consider and focus just on whether somebody is guilty or not guilty first, and then look at punishment second if you were to find them guilty? Is there anyone who's unable to do that? All right, 41, 46. All right, thank you. Now, the next thing I want to talk to you about is the English language. I love English. I love languages. I'm originally from Louisiana. So of course, when my friend suggested we take Spanish, I was like, we're not taking Spanish. I'm not going to take Spanish. I'm not going to need it. I'm going to be retired at 21. I'm going to be living my life in Paris and I'm in Louisiana. It's French. So of course, unbeknownst to me, I was going to end up in Texas and I should have taken Spanish. So is there anyone here? English is not your first language. Please raise your card. All right, 29, 44, 51, and 63. 29, what's your first language?
Spanish.
All right, have you been able to understand everything? Thank you. 44, you may be seated. 44, what's your first language? Have you been able to understand everything? 51, what's your first language? Have you been able to understand everything?
Yeah.
63, what's your first language?
Spanish.
Have you been able to understand everything?
Yes.
All right, thank you. That's odd. Usually we have a lot of languages thrown in. There's no Philippines in here. Usually we have at least, 22. What's your language?
We speak Filipino, but we grew up speaking English in the Philippines. Because our medium of instruction.
All right, thank you. And have you been able to understand everything?
Yeah.
Thank you. I knew someone from the Philippines was going to be here. All right, before I turn it over to the parties, I'm gonna tell you 2 stories and I have one more question. Other than meeting downstairs in the jury room and standing in the hallway, does anyone know anyone on the panel? All right, see, if one person, 3 people have raised their card, so all 3 of you should know each other. 22, 34, 63, 66. All right, juror number 22, who do you know?
Mr. James,
All right, that's 66. Thank you. How do you guys know each other?
we attend the same church.
Oh, okay, awesome. Thank you. Number 34, who do you know?
Len James.
Oh my gosh, you're popular. Thank you. How do you know each other?
For UIW.
All right, thank you. Number 63.
Glenn James.
Oh my gosh. All right, you are popular. Everybody knows you. And I'm assuming you know all of them.
No, I don't. I just know Glenn
No.
through, we used to train together,
Oh, awesome. And where were you all training?
with the same coach for triathlon.
All right, okay, awesome. All right, so I'm gonna tell you all 2 stories. They're both true. The first story I'm gonna tell you about is my uncle, and I always tell jurors the story because I want people to know that jury duty is an inconvenience, it's not a sacrifice. Your country only asks 2 things of you. They ask that 1, you pay your taxes, and 2, you serve on a jury. That's it. Raise your card if you've ever served and actually been on a jury trial where you were a juror. All right, so everyone look around. That is not even a third of the people here. You can lower them. So the country isn't even calling you up once a month or once every 3 months to serve. It's just really once in a blue moon when you think about it. And so I always tell people, I see people 4th of July, Memorial Day, they're waving flags, but I'm like, do you try to get out of jury duty? Don't do that. Because in order for us to have jury trials, we need jurors. So my uncle grew up in a small town called Grand Cane, Louisiana. Super intelligent, my grandmother's firstborn. Teachers would just skip him to the next grade because they tell my grandmother, they'd say, Miss Lang, we taught him everything we can teach him. And so they'd move him to the next grade. Now, when his brother and his sisters came behind him to go to school, they didn't like that much because all the teachers knew everybody and they would say, we've seen your brother, we're expecting a lot out of you all. You all better be super intelligent. So my uncle graduates, and when he graduates, the Vietnam War breaks out. And he goes to my grandmother and he asks my grandmother to sign for him so he can go because he said, you know, based upon what's happening, civil rights, everything, there's no way I can improve my lot in life, here. So I'm going to join the military. So my grandmother signed for him to go in the military. And I consider that a sacrifice because that's our firstborn. And when you think about it, nobody in the United States, my grandmother would always tell us this story when she was alive. Nobody in the United States really knew where Vietnam was. Nobody knew what it was about. My grandmother only had a 6th grade education, but she was super intelligent. She taught me how to read and write, and she would babysit while my mom was at work. But they only had 3 stations, ABC, NBC, and CBS. And NBC, I don't know if you would really call that a station because the weather had to be perfect. Otherwise, you were not going to get any picture. And then the thing about those 3 stations is young people, there wasn't this 24/7, 7 days a week thing. Programming would end and they played the national anthem. When they got advanced, the flag would just blow in the wind and you just wait for the next day for it to begin again. My grandmother did have a phone, but it didn't have the numbers on it, young people. I know you don't know what a rotary is or touch tone, but it wasn't a rotary, it wasn't a touchtone. You pick it up, when you pick it up, the operator would answer and you would tell them what you wanted. That's why they have songs like Beechwood 4, 5, 7, 8, 9. So when my uncle went off, all she could do was write him letters. There wasn't a computer, there wasn't an email. So she just knew his number. She wrote a letter and wait for it to come back. And she quickly learned that you don't want the military knocking at your door, anybody official, because that wasn't good news. So I tell people that's a sacrifice. With jury duty, people are only asking for this much of your time. It's not a sacrifice. It's an inconvenience. The other story I'm going to tell you is about my friend. She and I went to law school together. She was called up for jury duty. She practiced on the civil side, and usually, no shade to civil attorneys, but they're not in court every day usually. And so she said, hey, let's meet for lunch. I have jury duty. I'm like, great. So we're eating, we're having fun. I asked her, how's jury duty going? She's like, it's going fantastic and fabulous. Now that I'm judge, I'm like, how can it be fantastic and fabulous? I wasn't your judge. What are you talking about? So I said, what do you mean by that? She's like, oh, I'm not going to be selected. It's like law school. I'm in the back. I got my head down. And so I started laughing and she wanted to know what's so funny. And I said, you and I are going to get to have lunch all week. And so the easiest way to be on this jury, other than raising your card and saying, please select me, is to be quiet. And I tell you all that story because both the state and the defense are going to get 30 minutes to get to know you. That's all they get. They don't get the chance to go out with dinner with you and hear your opinions. It's just 30 minutes each side. Does everyone understand? All right, does anyone need a break? All right, and then Miss Abrams, the probation, you're right there. So here's the thing, Miss Abrams is here. She's a probation officer in this court. She's not involved in this case. You're gonna see people who come through this door. It's just for me to sign document. It's not about this case. The person sitting here is a student in my class. They're just here to observe. And when people come through that door, they're coming through that door because they don't see the sign that says, we're in jury trial. Please do not come through that door. And Miss Abrams always tells me, Judge, you didn't tell them what happened to your uncle. She's like, people want to know, did he make it back? So my uncle made it back, but he's since passed. So with that being said, I am going to turn it over to the state. Are you ready to proceed, state?
Yes, Judge.
Do you need?
Check your mark.
Sure.
All right, good afternoon, everyone. My name is Megan Galloway, and I have a confession to make to all of you. So early this morning, when I was on my way to work, it's no secret that there's a lot of construction that's going on downtown right now. And so when I was turning on Cesar Chavez, it merges into one lane. And I was in a hurry this morning with the rain. It was taking me longer than I anticipated to get to work. You can't hear me? Okay. So this morning it was taking me longer than I anticipated to get to work. And there was a car that probably doesn't travel downtown as much as I do. And they had to merge at the last minute. And I go, oh my goodness, any other morning I would let you merge, but not this morning. And so I'm confessing that to you all because if you see me and you say, hey, that's that jerk that did not let me merge this morning, speak now or forever hold your peace. Okay. So like the judge said, we're going to talk about, I know you all are probably feeling like, please, please, please don't call on me. But it is important that you guys respond to me when I, am asking you questions because the easiest way to end up on the jury is to remain silent. So, if you're not talking, that's probably what you're going to look like at the end of my 30 minutes and defense's 30 minutes and panel. Look at how happy we look. So I want to talk to you all about what the purpose of jury selection is. It's like the judge said, we're only going to talk about the law that applies. We cannot speak about the facts, but it's to learn about you all and find 12 fair and impartial jurors that can render a verdict according to the law and the evidence, okay? And so who can tell me who that is up there? Willie Nelson, okay, and what does Willie Nelson love? Marijuana, right? And so it's not a secret, right? It's really vocal about this. So if Willie Nelson was chosen to sit on a misdemeanor possession of marijuana case, what do you think that his verdict would be in the case? Not guilty, right? And that's because he fundamentally disagrees with that law. And that's fine, but that's just something that we need to know. And so I'm going to refer to something called the Willie Rule. And what I mean by the Willie Rule is, do you understand the law? Do you agree or disagree with it? And can you follow it ultimately? Okay? Like I said, we're just looking for fair and impartial jurors. That means that you're going to base your decision solely on the evidence and the law that's given to you from the court. Okay? And so I have a rule in my jury selection, and that is no walkaway. Okay, because a lot of times we get jurors in here and I ask them a yes or no question, and they're kind of like the little engine that could, and they're like, I think I can, I think I can. And I'm sorry to inform you, but in this setting, I think I can is not good enough. Okay, so I need you to commit to your answer, yes or no. Everyone got that?
Yes.
So the judge talked about this earlier. It's a burden of proof that lays solely on the state, and that is beyond a reasonable doubt. Like she said, there is no definition for that, but it doesn't mean 100%. It doesn't mean beyond a shadow of all doubt. And it goes to the elements of the offense, okay? And so, who can tell me what happened in this photo? Well, okay, who's come home to this before? By a show of hands or cards. Okay, juror number, what's your number? 5, okay. Can you please tell me what you think happened here? The dog got into the trash, right? And so how can we tell that, right? By looking at the facts and circumstances that are depicted in the photo, right? And so, you know, he's there, he's looking a little guilty. The trash is surrounding him. And so what I like to think about, and when I talk about the burden of proof, is what is reasonable and what's possible. So in this fact scenario, is it possible that someone maybe broke into the home, just scattered the trash on the floor, but there's no signs of forced entry? There was nothing taken out of the home, and this person just wanted to go in the home and dump the trash out and run out? It's possible, but that's not reasonable, right? And that is not what the evidence suggests, okay? Does anybody have any questions about that? So knowing that standard and that hypothetical that I just gave you all, is there anyone here that says, you know what, that's not good enough for me? In this case, I would require the state to prove their case 100%, beyond a shadow of doubt. Anybody? Number 46. Okay, anyone else? Juror number 23 and juror number 30 and juror number 1. Okay, and so you all are saying that you understand, right, the burden is beyond a reasonable doubt, that you would hold the state to a higher standard. Is that correct, juror number 1? The 2 that had cards over here, is that correct? What's your number? 23. Okay, thank you. All right. Is that correct, juror number 30? Okay. Juror number 46, your card raised? Okay, so that you would hold the state to higher burden. Okay. Now I have this question that I want you all to answer, and it's, what is your opinion of the criminal justice system? So you have 4 choices here. The first one being you think it's terrible and it takes away the rights of citizens. Choice number 2 is you think it's concerning because it interferes with the rights of citizens. Choice 3 is, did I say choice 30? Choice 2. Okay, then choice 3 is helpful. You think it looks out for citizens. And choice 4 is beneficial. It protects us from the harmful actions of others. So if you are with choice 1 and you think that the criminal justice system is terrible, would you please raise your card? Juror number 21. Okay, and is that based like on a personal experience? Okay, and would you be able to set that feeling or personal experience aside and render a fair verdict. No, thank you so much. If you are choice number 2, would you please raise your card? You think it's concerning and interferes with the rights of others? Okay, jurors 1, 2, 4, 20, 30, 36, 41, 57, 58, 65, 71, 73, and 74. All right, thank you so much. Juror 3. Okay. Not 2. Juror 2, did you by chance have your card raised? Okay. So who's with choice number 3 you think it's helpful and looks out for citizens? Okay. All right, juror 2, 9, 10 through 12, 14, 6. Okay, if I call your number, you can put your card down. Thank you. 15 through 19, 22 through 25, 27, 28, 31, 33, 35, 39, 40, 42, 44, 46, 47, 49, 50, 51, 54, 56, 59, 60, 61, 67, 70. Thank you. And then choice number 4, please. Is 5, 7, 8, 13, 26, 29, 34, 37, 38, 43, 45, 48, 55, 62 through 64, 66, 68, 69, 72. Thank you. All right. Now, earlier the judge mentioned something about a multi-count indictment. As she stated, the indictment is not evidence of anything. It's a vehicle by which the state gives the defendant notice of what he's being charged with. Okay, and so there is such thing called a multi-count indictment, and that means that maybe the fact circumstances falls under 2 categories of penal code. Okay, and so we're going to talk about that a little bit in depth. So count 1 in this case is aggravated robbery, and there are multiple elements that we have to meet in this case. Okay, so the first would be on or about the offense date. In Bear County, Texas, the defendant, while in the course of committing theft of property and with intent to obtain and maintain control of said property, did use and exhibit a deadly weapon and did intentionally or knowingly or recklessly cause bodily injury to the victim. Okay, and we'll talk about some of the terms in depth just in a little bit. Now, 2 is aggravated assault causing serious bodily injury. So there are some elements up there that we have to meet under count 2. And so that's on or about the offense date in Bear County, Texas. The defendant did intentionally or knowingly or recklessly cause serious bodily injury to the victim. Okay. So let's talk about the mental states, right? Intentionally is defined as the defendant's conscious, objective, or desire. So when I think about that, I think, did the defendant mean to do that? Okay. Knowingly means that the defendant is aware of the nature of his conduct or circumstances that exist at the time of the offense. So when I think of that, I think, did the defendant know what he was doing when he did what he did? And the third mental state is recklessly. That means that the defendant was aware of but consciously disregarded a substantial and unjustifiable risk that the result will occur. So when I think about that, I think, did the defendant know that there was a big risk that could happen when he did what he did and he did it? Okay. So regarding mental states, the law says that you do not have to be a mind reader. You can infer this from facts and circumstances and actions. And so I have a hypothetical that I like to illustrate with the movie Titanic. Okay, it's one of my favorite movies. And if you haven't seen it, don't worry. I'm going to tell you everything you need to know for the hypothetical. Okay, so there's 3 characters at play here. It's Cal Hockley, Rose DeWitt Bucator, and Jack Dawson. And so in this hypothetical, we are going to look at the circumstances to determine what is Cal's intent. Okay, so first we know that Cal grabs a firearm from his personal attendant and he starts shooting it at Jack and Rose. And so while he's shooting this, Rose has a necklace called the Heart of the Ocean in her jacket that she's wearing, and Cal wants to get it back. Okay. And so there are also many other people that are in the crosshairs when he's firing this firearm, and he chases them down without regard for any of the bystanders that are passing by, and he continues to shoot at them until the magazine runs out of bullets. Okay. So you, sir, I'm gonna pick on you. What is your number? 13. Okay, what do you think Cal meant to do when he was engaging in this action? He's trying to get the necklace back. Okay. And what's your number? 18. Okay. Do you think that Cal knew what he was doing when he was engaging in this action? Yes. Okay, and what facts can we look at to determine that, right? Right, that he grabbed the firearm, right? He continued to discharge it until it ran out of bullets, right? Okay. And what's your number? I'm pretty sure. Yes. 29.
29.
Okay, and so what do you think, what risk did Cal disregard when he was engaging in that conduct? Right. Very good. Thank you so much. So when I think of aggravated robbery, I like to think of it as we're going from theft, which is a misdemeanor offense, and there are certain enhancements that will get you to aggravated robbery. So we're going to talk about that in detail. So first we'll talk about what is a theft. Well, the law says that a theft is committed when a person unlawfully appropriates the property from another with the intent to deprive the owner of the property. So I'm going to use juror number 1 as an example. So she has this bag, right? And I don't know juror number 1 and she doesn't know me. So let's say during the break, I, don't have any conversations with juror number 1. And when she goes out, she leaves her bag here. And I decide, you know what? I don't get paid that much working for the county. So I'm going to go through juror number 1's wallet and see if she has any money. Well, what would that be? A theft, right? Because I don't have the owner, right? It's her property and I don't have her consent. I didn't ask her for the money. I'm taking it without her consent. Does that make sense? Okay. Does anybody have any questions about that? Okay, so that's the predicate offense of theft. So now, and just the law defines owner as either the person that has possession of the property, whether their possession is lawful or not, or the person that has the greatest right to possession of the property other than the defendant, okay? And so when we take the offense of theft, we get, if we add a threat of bodily injury or death or causes bodily injury, that is what equals a robbery. So in my hypothetical, let's say I'm feeling a little brazen today and in front of everyone, I'm deciding I want to take juror number 1's bag. And so I slap her across her face and I take the bag. What would that be? A robbery, right? Because, well, I should have explained this to you first, but bodily injury is defined as physical pain, illness, or any physical impairment. And so if I slapped juror number 1 and she said, wow, that slap hurt me and I took her property in the process, that is a robbery, okay? Does anyone have any questions about that? Yeah. So once we're at robbery, in that same hypothetical, let's say that I have a firearm in my waistband. And we're going to use that same fact pattern. But this time, after I slap her, I flash the gun at her, right? Or let's say I slap her really hard and I fracture a bone in her face. That would be serious bodily injury. So the way that you would get to the aggravated is that you use or exhibit a deadly weapon, which in my hypo would be the firearm. And or you can cause serious bodily injury, which in the hypo would be the fractured bone to the face. Okay, And so that's how you get aggravated. Does anybody have any questions about that? Okay. And so serious bodily injury by the law is defined as serious permanent disfigurement. And so under aggravated robbery, like we just talked about, to get at, one way is that you can use or exhibit a deadly weapon. So I want to talk to you all about what a deadly weapon is. Do I have any volunteers? Raise your card if you want to take that. Your number 7.
Gun.
A firearm, right? Your number 13. A knife, correct? Your number 9. Baseball. Very good. And your number 15. A utensil. Okay, those are all very good examples. So a firearm is a per se deadly weapon. Okay, but the definition that I like to use is a deadly weapon is anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Okay, it doesn't have to actually cause it, but it has to be capable. So let's talk about that. So a pillow, right? Let's say that there are 2 roommates and they're at college at UTSA and they decide that they want to have a pillow fight. Okay, so in the manner of its use, if they're just hitting each other with that pillow, do you guys think that that's a deadly weapon? Yeah. Okay, so let's say that one roommate just really dislikes the other roommate. And while the other roommate is sleeping, the roommate goes and takes a pillow and suffocates the other roommate. Would that pillow be a deadly weapon in that instance? Yes. Okay, so does anybody have any questions about that in the manner of its use or capable of causing accident or death? Okay. Now, I talked about this earlier, but right, it says an owner is a person that has possession of the property, whether lawful or not. Okay, that's the law. And I have a hypothetical that I want to demonstrate this with. So it's Titanic again, and we're back to the heart of the ocean, right? And so this is Cal. He was engaged to Rose, and during their engagement, he bought her that very nice, expensive necklace, and he gifted it to her. And so in the hypothetical, right, earlier, he was using a firearm to get it back, which is an aggravated robbery. But who here has the greater right of possession? I'm gonna call on juror number 4. Who do you think has a greater right of possession in the hypothetical? Okay, so let's look at the law. It says the owner is a person that has actual possession, so that's care, custody, and control, right? If I wanted to possess this hand sanitizer, right, I'm possessing it right now because I'm holding it. It's under my care, custody, and control, right? So that's what possession means. And so whether lawful or not, or who has a greater right to possession. So knowing that, I'll pick on somebody else. You, what is your number?
7.
Okay. Who do you think has a greater right to possession of the necklace?
I would say her because he gifted.
Because he gifted it to her, right? Okay, and so so do you think that Rose is free to do whatever she wants with that necklace?
Yes.
Okay, so who says, no, she's not free to do whatever she wants with the necklace? If you feel that way, raise your card. Juror number 71. Okay, so you feel that Cal's still the owner of the necklace.
Gator ring kind of thing too. It's not really heard until the act of marriage goes through, I guess.
Okay, you're adding some facts that I didn't, that are not in the hypothetical. Let's stick to the fact that I did.
Present, so.
Okay, so does anybody feel the same way as juror number 71? Juror number 36. Okay, juror number 23. So you feel that he's still the owner even though he gave it to her? Does anybody else feel that way? Please raise your card. Okay. And so what are some things that can help us determine who's the owner, right? It's who has actual possession. So it's Rose, right? Because he gave it to her. And in the movie, I should have put these facts in the hypothetical, but she's had it for some time, okay? It's not just a couple of hours. She's had it for some time. So we can look at who has actual possession. So it's her, it's in her pocket in the hypothetical I gave earlier. The length of actual possession, like I said, she's had it for some time, and the reason that it was given. Okay, so those are some things that we can look at to determine who's the owner of something. Does anybody have any questions about that? Okay. So the law says that it's not a defense that a defendant has an interest in the property that was stolen. If the owner has exclusive possession, so that's kind of talking about like Cal in the hypothetical when he's using the firearm to get his property back. If he was charged with aggravated robbery, he cannot sit there and claim, well, actually, it's my property, because that's not a defense under the law. Does anybody disagree with that? If you do, raise your card, please. So I'm going to talk to you all about what type of evidence you expect to see in this case. Does anybody, sir, I'll ask you, what's your number? 17. Do you have an idea of maybe something that you're expecting as far as evidence? No? Maybe like photos or?
Oh, you mean what could you? Police reports. Medical reports.
Well, police reports, there are some special rules, but those are some good answers. Let me see, what's your number? Your number 19, do you have maybe some idea? Very good, that is exactly the answer I was looking for. Thank you, because testimony and evidence, right? And so earlier when I was talking about, you know, whether somebody would hold the state to a higher burden and make us prove our case, you know, 100%. The only way that we would be able to do that, or that you would be 100% sure, is if you were a witness in the case, right? And so the way that you receive evidence is through testimony. So that's whoever comes up here and takes that witness stand and tells you that. Okay, and so is there anyone here that would expect to see the property that was allegedly stolen? Juror number 7. Okay, 31. Okay. Okay, juror number 1, 6, 14. Well, before I take your cards down, I'm gonna ask you, why do you guys think the state would be unable to bring you this evidence? Does anybody have an idea? Jury number 2, what was that? Can you say it a little louder? It could be gone, right? It could be sold. That's a good one. It could be pawned. Because what would someone want? What would someone do if they didn't want to be found that they committed the crime? Juror number 4. They would get rid of it, right? That's a concept that we all know, right? Luca Brasi sleeps with the fishes. So is there anyone that would require the state to produce the item stolen or a photo of it? Knowing what we just went over. Okay, juror number 46. Raise your cards, keep them up. 1, 6, 18, 23, 30, 31, 35, 36, 22, 40, 42, 44 through 46, 53, 65, 67, 68, 73. All right, thank you. And my point in that is that we take our cases as we find them, okay? Like juror number 2 said, a lot of the times law enforcement's not able to recover the property and there's nothing that we can do about that, okay? So is there anyone that thinks that the state shouldn't go forward on cases where the property is not recovered? You're shaking your head, go ahead and raise your card up. Okay, 53, thank you. Does anybody agree with him? Great.
5 minutes.
Thank you, Judge. As far as witnesses, you may hear from a lot of different witnesses. There may be law enforcement, civilians, which are referred to lay witnesses. You could maybe hear from the defendant or any defense witnesses that they choose to bring. But as far as that goes, you all are the exclusive judges of the facts proven, credibility of the witnesses, and the weight to be given to the testimony. And so I have a question for you all. What does a victim of crime look like in Bexar County, Texas? So I'm gonna pick on you with the glasses. Jordan. Yes, what's your number? Okay, thank you. And so what do you think the victim looks like in Bear County? Interesting.
Excuse me, if you could stand.
It's kind of a trick question, right? It could look like anyone, right? It could look like anyone. It could look like anyone in this room, any of your friends, family members. They can have tattoos, they could live on any different part of the town. And so keeping that in mind, right, you will determine the credibility of the witness, but something that I like to look at when, you know, determining someone's credibility is whether their story has changed, whether they're consistent, and whether they have a bias or what motive do they have by showing up and taking the stand. Okay. And so would anybody here hold it against a complainant if they had tattoo? No? Okay. All right, and so does anyone know who this is? Mulan, right? And so in this part of the movie, she sings a song called Reflection. And the reason that I have that up there is because during the jury trial, if you're selected to sit on the jury, you may look at the defendant at one point or another and say, hey, he reminds me of my father or my brother or my cousin or my best friend. But in the law that the judge gives you, you're going to be instructed that you cannot let sympathy play into your decision. And so is there anybody here that would not be able to set aside their sympathy and render a fair and impartial verdict? Juror number 4, juror number 1, juror number 4, juror number 16. Okay, that's kind of a lot. Keep your
All right,
cards
now,
up.
now let me pause you.
Okay.
All right. You're gonna get the law from the court. I will give you the law and what the law is. So, for example, if your mom is on trial for an offense, maybe the defense would want you on the jury, maybe they wouldn't want you on the jury. It depends on whether your mom likes you or not, right? Maybe the state would want you on the jury, maybe not. So when you are looking at cases, if you're on the jury, you're not supposed to say, oh my gosh, I feel so sorry for that person, so I'm going to find them not guilty. Or you're not supposed to be on a jury saying, oh my gosh, you know what? I really don't even like the way that person looks, so I'm just going to find them guilty just because. You're supposed to base your decision on whether somebody's guilty or not guilty based upon the evidence that you hear. Does everyone understand? Yes. So, is there anyone here who will not be able to do that? Is there anyone here who's going to say, you know what? That person looks like my brother, or that person looks like my sister, or that person looks like my mother. So I'm going to be sympathetic towards them, and I don't care what the evidence that's presented. I'm going to find a person not guilty. Or either that person looks like my ex, or that person looks like the person who did me wrong. So no matter how the state doesn't prove their case, I'm going to find that person guilty because that's who they remind me of. You're not supposed to let bias, sympathy, or prejudice play any role in your decision making. So based upon that and the question that the state asked you, is there anyone here who cannot do that? And if you cannot do that, raise your card. There you go.
Oh, thank you, Judge. Okay, juror number 21, 22, 27, 30, 31, 36, 41, and 52, and 58. All right, now, like the judge said, there are 2 phases. Should we get to punishment phase? I have this question, and it is, what is the main purpose of sentencing for violent crime? So you have 4 choices. 1 is punishment. If you do the crime, you do the time. 2 is deterrence. It's preventing this from happening again. 3 is making amends, helping the victim recover. And 4 is rehabilitation. Everyone messes up and can change.
1 minute.
Thank you, Judge. So who is rehabilitation? Okay, who is punishment? You think that that's the main purpose of sentencing for punishment? Okay, thank you. Is anybody rehabilitation? The rehabilitation, raise your card. Okay. 3, 4, 28, 31, 38, 41, and 42. And who is making amends, helping the victim recover? 40. And so I have another question. What's the most important factor to be considered when assessing punishment? So there's upbringing, criminal history, the seriousness of the crime, and impact. Who is criminal history? What's the most important factor to be considered when you're assessing punishment? Upbringing, criminal history, seriousness of the crime, or the impact on the victim. Whose criminal history raise a card? 64 and 67. Who is the seriousness of the crime? Okay, thank you. Who's the defendant's upbringing? 52 and 73. And whose impact on the victim? Jury number 9.
All right, time.
Thank you, Judge.
All right, ladies and gentlemen, is there anyone who needs a break? All right, so I'm gonna give you all a break. I'm gonna ask that everyone be back here no later than 4:20. So everyone look to your left, look to your right. You're responsible for that juror. So you all can leave your items in here, but leave the numbers behind, and you are not excused. So you need to line up outside and be outside lined up by 4:20. All right, thank you. Good job. Oh, thank you.
Judge. Mind if I use that way?
Yes, you can. And if you can turn the screen back this way, please.
Yes, Judge.
Thank you. Oh, thank you.
Just remembered I got my jury summons card yesterday when I got home.
Oh, hey, well, you need to do that.
I don't remember what the date was though, and I don't.
And excuse me, state. This was dropped off for you.
In his pocket on purpose. Bad. So, you know. Watching up and I put my phone down. Salaries.
Do we have everyone? All right, defense, you may proceed.
Thank you, Your Honor. Good afternoon, folks.
Good afternoon.
Here, Ms. Martinez, I'm gonna let you borrow my pen. Now, got your 20. Mr. Torres, right? Yes. I can borrow my pen. That's my pen. It says Porsche, North Houston. I don't know Porsche. That a robbery?
No.
Why?
You got them borrowed.
Yeah, it's my pen, right? I took my pen back. So, is any member of the juror in agreement with me that you can't rob your own property? Right?
Right.
Oh, raise your card.
How do we know this guy knew it was your pen?
Pardon?
How do you know it was your pen?
Because it says Porsche North Houston, and I knew that was my pen.
You did it to the first person, not to him.
All right, so everyone, please make sure you stand.
Stand, please. Your number? Okay. So your position is that I gave it to Ms. Martinez, who let Mr. Torres have it, and then I got it back from Mr. Torres. That's the happened, right? Okay, so your problem with that is what?
Is that maybe he didn't know, he probably didn't know.
Well, but he doesn't have to know it's my pen. I identified it and I took it from him.
Anybody can see that.
All right, but I identified my property. Yes, 69.
May have made more than one pen, and how did you get it back?
Well, I grabbed it from him. No. But that's a theft. It's the same element, right?
So there are a lot.
Okay. And your number, hold your number up. Juror 19. You lend your card to juror number 18. All right? Juror number 18, you lend your card to juror number 17.
My car or his car?
Well, whose car is it? That's a good question, right? Uh-huh. So can you steal your own property? If for some reason or another juror 16 steals the car and I want it back, is it a theft of my own property?
Yeah.
You're getting your own.
Because you haven't shown proof that it's your property.
I got a title. I identified it. Okay, I identified it. It's clearly my property. I said, this is specific about it.
You have to go through the court to take it back. You can't just go get it.
Why not? It's my property. Are you saying that so you have no property rights? Is that what you're telling me? No one has a property right to their own property?
I mean, I would call the police and get my property back.
Well, but the police is not gonna do anything. You just ask them, give me my car back. All right? It's, what I'm trying to get to the point is, can you steal your own property. That's what I'm trying to get to, okay? Regardless of all the intricacies in here, whether you can prove it or not, the bottom line is, you all agree with me, you can't steal your own property, right?
Right.
All right. Oh, 45, did you have a question?
Did, the way you presented the scenario about the car being borrowed, you said, I'm loaning you my car, and then you said your car again, so in reference, that's two different vehicles, her car and your car.
Well, no, because I never gave it to her, she just borrowed it.
But she borrowed your car, and then you said you loaned your car to this person, that's two different cars, it's the way you present the scenario.
Okay,
Yeah.
you're confusing then.
I'm
It's the
not-
same car, same car.
But you didn't present it that way.
All right, maybe that's my fault then, but we're talking the same piece of property, not a different vehicle. Okay, but anyway, regardless of the fact, you all agree, you can't steal your own property. Yes, sir.
Doesn't it come down to the definition we saw of ownership, whether it's legally owned or not?
Well, that means that anybody can take under that definition, which is incorrect, anybody can take your own property and claim it. And you think that's right?
No, the first one would be bribery, right?
Right.
But then if they turn around and give it to somebody else who doesn't know that they robbed it, then you go and get it back from that person who has possession ownership at that time, whether it's legal or not.
Well, if I leave my piece of property at somebody's house and they know it's my piece of property, all right? And they say they turn around and lend that piece of property to somebody else, and you see that property and you can identify it's your piece of property, you absolutely know it's yours. You're telling me you don't have a right to get your property back? And go to, yes, sir.
How long you left it there?
Well,
I think you do have a right to go get it.
Yeah.
But you don't just go steal.
well, how can you steal your own property? That's my question. How do you steal your own property?
Definition of ownership.
Okay. Definition of ownership. Under your definition of ownership, that means no one actually has a property right.
Those are my definition.
Well, all right, but think about it. Put it in common sense. This minute, sir. Put it in common sense. Somebody takes your property and it automatically, under that definition, becomes their property? No, right?
No,
It doesn't make any sense.
that wasn't the scenario that you gave it. You lent it to somebody who then gave it to somebody else, and now you're going and taking it from the third person.
All right, so everyone, I'm gonna need you all to make sure that if you're in the area that you stand and you can't do the conversational thing, just raise your card, stand, respond, so the court reporter can take down everything that's being said. All right, no problem.
All right.
Counsel, you may continue.
We're gonna move on to something else. Juror number one, you said you want the state to have a higher burden of proof than beyond reasonable doubt. I didn't quite understand the proofs. Fine.
I can't hear you. I would need to think about that for a minute, but we were in that scenario. It was in regard to that scenario.
Yeah,
And I kind of forgot what the scenario is. That's fine.
okay. But you understand as a juror, you sit here and you hear all the evidence. The state has a certain burden of proof, each and every element of the offense. And if they don't prove each and every element of the offense beyond a reasonable doubt, then what do you have to do? Find them not guilty. They didn't prove the case, right? All right, reasonable doubt means not absolutely all doubt, but common sense. That's the main point, common sense. Look at everything and you make a determination. Is there enough proof beyond a reasonable doubt to find this person guilty? Because that's your job. You find them guilty, you deprive that person of life and liberty. If you find them not guilty, it means the state didn't meet the burden of proof. I always get a big kick out of the dog with the garbage because I'm looking for the cat in the back. Okay. I think juror number 23, you had the same issue, didn't you?
Yes, sir.
All right. What kind of proof would you require beyond a reasonable doubt?
Testimony.
Okay, well, that's the evidence, right? You're the judge of the credibility of the witness. So if you believe the witness is telling the truth, he's got no credibility, right? If you believe the witness is telling the truth, then that's evidence. Then go to it beyond a reasonable doubt. That's what we're talking about. So yeah, you will hear evidence. The state has to present evidence to win their case. That's the way it works. So you would be able to follow the rules and follow beyond a reasonable doubt, right?
Yes, sir.
With the evidence. Okay. Juror 30. Where you hiding?
Yeah, the same.
Same thing, same issue. And 46, right? Where's 46 hiding? Yes, ma'am. Same issue? All right. Okay. Who all's retired here on the jury? Juror 2, what'd you do before you retired? Okay. What hotel? Jury 4?
Hotel as well.
Pardon?
Hotel as well.
Okay. Juror 17.
Business executive.
Okay, 22.
Then the time from the Department of Defense as a budget analyst.
Okay, 23.
The Air Force.
Oh. I think so, just some retired people. 42. Where from? Okay, 43.
Los Angeles County Government.
We knew there was one in here. 56.
CPS energy.
Okay, and 57. What? Thank you for your service. 61.
Air Force Civilian Program.
Okay, thank you. Okie dokie. All right. One question that wasn't asked that I always ask every time is I respect individual religious beliefs. Is there anyone in this jury panel who cannot sit in judgment of another person because of their religious beliefs? Okay, on the members of the jury panel who have been previous jurors in a criminal case, can y'all raise your card? Juror 2, no, criminal civil? Civil. So you all were Thomas J. Henry handing out cash?
Something like that.
Yeah, okay. Okay. 17, did you reach a verdict?
We did.
Guilty or not guilty?
We sent him to the hospital.
Okay, so it was basically insanity.
Yes.
Okay. Juror 30,
They were with the plea bargain.
plea bargain, 31,
Pled guilty.
guilty. What kind of case was it?
It was her abuse.
Oh, okay. 34?
The distribution of marijuana.
Oh, okay.
I'm sorry.
Was it Willie Nelson?
Can't say.
It's a distribution of marijuana.
42?
Criminal case.
What kind of case?
I don't remember exactly what the criminal case.
It was a while ago, huh?
It was, yeah.
All right. All right. Of those who sat in a criminal trial, how would you all rate your experience? Good, bad, fair?
It's okay.
It was okay. All right. We'll go with that. Thank you, ladies and gentlemen.
All right, ladies and gentlemen, I'm gonna have you all step outside. I'm gonna need everyone to please take your items with you. Do not leave any personal items behind. And please leave the numbers behind. You are not excused, so do not leave this building. Everyone, please rise for the jurors.